Ladies and gentlemen, I thank you very much for joining me today. During this presentation, I am going to provide you with an in-depth analysis of the Public Records Act, which is a vitally important part of our job as city employees. At the conclusion of the presentation, there will be a test to reinforce what you have learned today. This entire presentation is an explanation of the Public Records Act in Florida, which is contained within Chapter 119, Florida Statutes, as a further expansion of Article 1, Section 24 of the Florida Constitution. So, what are public records? Public records are essentially all materials made or received by the city in connection with official business, which are used to perpetuate, communicate, or formalize knowledge. Just remember the acronym PCF. If the purpose of a document prepared in connection with the official business of the city is to perpetuate, communicate, or formalize knowledge, then it is a public record regardless of whether it is in final form or the ultimate product of the city. Accordingly, any city document, however prepared, if circulated for review, comment, or information, is a public record regardless of whether it is an official expression of policy or marked preliminary or working draft or with a similar label. Personal notes can constitute public records if they are intended to perpetuate, communicate, or formalize knowledge of any type related to city business. However, public employees' notes to themselves, which are designed for their own personal use in remembering certain items, do not fall within the definition of a public record. Personal notes are not public records if the notes have not been shown or transcribed or shown to others and were not intended to perpetuate, communicate, or formalize knowledge. Private emails stored in government computers do not automatically become a public record by virtue of that storage. However, if there are allegations of misuse of city equipment for private purposes, the personal emails obtained as part of the investigation would be public records and subject to disclosure. So, be prudent when using city equipment. Billing documents regarding personal calls made and received by city employees on city-owned or city-leased cellular telephones are public records when those documents are received and maintained in connection with the transaction of official business. And the official business of a city includes paying for telephone service and obtaining reimbursement from employees for personal calls. Information stored in a city computer is as much a public record as a written page in a book. Thus, the Public Records Act includes computer records as well as paper documents, tape recordings, and other more tangible materials. Email and text messages, whether on city equipment or personal equipment, made or received by city employees in connection with official business are public records and subject to disclosure in the absence of a statutory exemption from public inspection. The placement of material on any city department's Facebook page would be in connection with the transaction of official business and thus subject to the Public Records Act. The city must only provide a copy of a public record in a particular medium requested by the person making a demand if the city maintains the record in that medium. For example, if a request comes in to have all memoranda sent by the Public Works Director to her employees be put on Laserfiche, but yet all of the memoranda so requested are contained in a filing cabinet at Public Works, the city need only provide paper copies of the memoranda out of the filing cabinet. Conversely, if the memoranda are maintained on Laserfiche and in the filing cabinet, the city needs to provide all of the memoranda on Laserfiche as it was requested in that medium. The city is not generally required to reformat its records to meet a requestor's particular needs. The city is not required to create public records at any time. If the information does not exist, such as a summary or analysis of data, we are not required to create it. The intent of the Public Records Act is to make available to the public information which is a matter of public record in some meaningful form, not necessarily that which the applicant prefers. However, the city may be required to provide access through a specially designed program prepared by or at the expense of the applicant where available programs do not access all of the public records stored in the city's computer databanks, or the information in the computer accessible by use of available programs would include exempt information necessitating a special program to delete such exempt items, or for any reason the form in which the information is proffered does not fairly and meaningfully represent the records, or, finally, the court determines other exceptional circumstances exist warranting this special remedy. The Public Records Act authorizes but does not require the city to provide remote electronic access to public records. Financial records are generally open to inspection unless a specific statutory exemption exists. For example, the city's budget and working papers used to prepare the budget are normally subject to inspection. Bank account numbers and debit, charge, and credit card numbers held by the city are exempt from public disclosure. The general rule with regard to personnel records is the same as for other public records. Unless the Florida legislature has expressly exempted the city's personnel records from disclosure or authorized the city to adopt rules limiting access to such records, personnel records are subject to public inspection and copying. The courts have rejected claims that constitutional privacy interests operate to shield the city's personnel records from disclosure. Additionally, courts have refused to deny access to personnel records based on claims that the release of such information could prove embarrassing or unpleasant for the employee. The city is not authorized to unilaterally impose special conditions for the inspection of personnel records. An automatic delay in the production of any public record is invalid. Thus, the city is not authorized to seal disciplinary notices and thereby remove such notices from disclosure under the Public Records Act. Nor may the city agree to remove disciplinary records from an employee's personnel file and maintain them in a separate disciplinary file for the purposes of removing such records from public access. Social Security numbers held by the city are confidential and exempt from disclosure requirements. The Public Records Act requires no showing of purpose or special interest as a condition of access to the public records. Each and every employee of the city who has a public record in his or her possession is deemed to be a custodian under the Public Records Act. Hence, when you hear the term custodian anywhere in this presentation, please remember that I am speaking about you and your duties under the Public Records Act. The custodian is not authorized to deny a request to inspect and/or copy public records because of a lack of specifics in the request. A custodian of public records and his or her designee must acknowledge requests to inspect or copy records promptly and respond to such requests in good faith. A good faith response includes making reasonable efforts to determine from other officers or employees within the city whether such a record exists, and if so, the location at which the record can be accessed. The only delay in producing records permitted under the Public Records Act is the reasonable time necessary for the custodian to retrieve the record and delete those portions of the record the custodian asserts are exempt. Nothing in the Public Records Act requires that a requesting party make a demand for public records in person or in writing. If the city believes that it is necessary to provide written documentation of a request for the public records, the city may ask that the requester complete an appropriate form or document. However, the person requesting the public records cannot be required to provide that city-created form or document as a condition precedent to the granting of the request to inspect or copy public records. A custodian is not required to give out information from the records of his or her office, however. What that means for you is that the Public Records Act does not require the city to produce an employee to answer questions regarding the public records produced. A custodian of a public record who contends that a record or a part thereof is exempt from inspection must state the basis for the exemption, including a statutory citation to the exemption. Additionally, upon request, the custodian must state in writing and with particularity the reasons for the conclusion that the record is exempt from inspection. Additionally, upon request, the custodian must state in writing and with particularity the reasons for the conclusion that the record is exempt from inspection. Where a public record contains some information which is exempt from disclosure, the Public Records Act requires the custodian of that document to redact only the portion of the record for which a valid exemption is asserted and to provide the remainder of the record for inspection and copying. The fact that the city believes it would be impractical or burdensome to redact confidential information from its records does not excuse non-compliance with the mandates of the Public Records Act. The Public Records Act is to be liberally construed in favor of open government, and exemptions from disclosure are to be narrowly construed. Providing access to public records is a statutory duty imposed by the legislature upon all record custodians, including yourself. Please remember that you are a custodian of the public records in your possession. The Public Records Act is not to be used as a profit-making or revenue-generating operation. The information must be open for inspection without charge unless otherwise expressly provided by law. The Public Records Act authorizes the imposition of a special service charge when the nature or volume of public records to be inspected is such as to require extensive use of information technology resources or extensive clerical or supervisory assistance or both. The charge must be reasonable and based on the labor or computer costs actually incurred by the city. The city may charge a fee for copies provided that the amount of the fee does not exceed that authorized by the Public Records Act or established elsewhere in the Florida statutes for a particular record. The Public Records Act states that if the nature or volume of the public records to be inspected or copied requires extensive use of information technology resources or extensive clerical or supervisory assistance or both, the city may charge that special service charge, which shall be reasonable and shall be based on the cost incurred for such extensive use of information technology resources or the labor costs of the personnel providing the service that is actually incurred by the city or attributable to the city by virtue of the clerical and supervisory assistance required or both. The special service charge applies to requests for both inspection and copies of public records when extensive clerical assistance is required. The fact that a request involves the use of information technology resources is not sufficient to incur the imposition of the special service charge. Rather, an extensive use of such resources is required before the special service charge is authorized. The term labor cost, for purposes of the special service charge, may include both salary and benefits of the personnel. However, the statute requires that the special service charge be reasonable and based on actual costs incurred. A policy to require an advance deposit is prudent and is desired by the city clerk's office. Given the Florida legislature's determination, the taxpayer should not shoulder the entire expense of responding to an extensive request for public records. Similarly, the city may require that a public records requester pay past due fees for records compiled for a previous request before complying with the requester's subsequent request. If you have any questions as to what charge should be assessed, please promptly contact the city clerk's office. A person who has been denied the right to inspect and/or copy public records under the Public Records Act may bring a civil action against the city to enforce the terms of the Public Records Act. The Public Records Act provides that if a civil action is filed against the city to enforce its provisions, and the court determines that the city unlawfully refused to permit a public record to be inspected or copied, the court shall assess an award against the city for the reasonable cost of enforcing the Public Records Act, including reasonable attorney's fees. In addition to judicial remedies, the Public Records Act provides that a public officer, like an employee like yourself, who knowingly violates the provisions of the Public Records Act, knowingly is the key, is subject to, number one, suspension and removal from employment, and number two, could be found guilty of a misdemeanor of the first degree with possible criminal penalties of 1 year in prison, a $1,000 fine, or both. A public record may be destroyed, however, or otherwise disposed of only in accordance with the retention schedules established by the Division of Library and Information Services of the Department of State. If you have any questions regarding retention schedules for public records, please contact the city clerk's office promptly. You may also direct any such questions to the Department of State, Bureau of Archives and Records Management at 850-245-6750. That's 850-245-6750. If you have any further questions after watching this presentation today, please contact any attorney in the city attorney's office, including myself. Thank you so much for your time. I sincerely appreciate it and wish you a blessed day.